Welcome back to part 2 of our presentation. We are discussing sources of law and the education system.
Mr. Law.
Yes, Miss Statute.
Have you noticed that we do not have arms and legs?
Actually no. But now that you mention it, I am rather alarmed. However, it does not appear to interfere with my body movements.
Mr. Law.
Yes, Miss Statute.
Please do not do that again.
Do forgive me. Now, on with the lesson.
From what you learned in Part 1, you can now see that the authority for local-level school district rules and regulations emanates from 3 primary sources. 1. The power delegated to local schools and agencies via the state constitution. 2. Statutes enacted by the General Assembly. And 3. State-designated educational agencies. This diagram shows how that vested authority then moves from the school board down to the individual school level.
It is interesting to note that many times, local policy can be in conflict with the Constitution, federal, or state laws.
What do you mean we have a policy that is unconstitutional? We have been doing it this way for years.
Well, situations where local policy has been unchallenged and remains in effect are common. Many times, local community values outweigh the letter of the law.
In fact, after this presentation, we will explore an actual school district dress policy that is in conflict with case law, but has never been challenged. Moving on, this diagram represents the pecking order of the many sources of laws, rules, and regulations that govern or influence schools. We will look at a significant amount of case law in this course. Notice that case law occurs only after laws and regulations have been established.
Case law is the third fundamental influence on education. It is built on stare decisis. This is a Latin term meaning, to stand by that which is decided. This is the principle that court rulings are to be based upon legal precedents declared in earlier courts. However, courts are not strictly bound by legal precedent. A comparison of how similar the factual situation of a case is, to a prior case, is always involved.
Case law is not always well settled. Conflicting opinions can occur among different federal district courts and in courts of appeal. Remember though, federal Supreme Court rulings have the full force of the law, and can only be altered by another Supreme Court decision or an amendment to the Constitution.
This slide shows the 3 functions of the court system. Let's discuss each in detail. First, the court may be asked to settle a dispute by applying principles of law to a specific set of facts. An example might include a school that performs extensive blacktopping or landscaping of a campus that results in an alteration of local drainage patterns. The owners then sue the school for damages and correction of the problem. In this instance, the courts would apply principles of law relative to property alteration. They would answer the question, was building code properly followed? Very boring. Unfortunately, this is the least common type of school litigation.
Legislation is frequently passed that is open to interpretation. Parties opposed to the way a law is implemented can file suit asking the court to interpret the law. In these scenarios, the court assumes that the law is constitutional and that the burden of proof is on the plaintiff, that is, the one who brings the complaint. No Child Left Behind, for example, has been challenged in court many times unsuccessfully. And finally, it is a basic assumption of our legal system that legislative and administrative action is constitutional unless challenged. As previously mentioned, there are times when school board policies or administrative actions are unconstitutional. The court may be called upon to evaluate such complaints.
There you go again. What are we doing that is against the law?
Patience, Mr. Skeptical School Board Member. You will see what I mean in just a few minutes.
Well stated indeed, Miss Statute. Do you mind if I explain this next slide?
Be my guest, Mr. Law.
There are 2 court systems or legal tracks in the United States. The federal court system decides issues related to the U.S. Constitution. The state system decides matters under the jurisdiction of state constitutions and state legislation. However, state and federal court paths often cross. In fact, many educational matters that are brought before the federal Supreme Court originated as state-level cases that crossed into federal jurisdiction. Most of these cases deal with alleged violations of the 10th or 14th Amendment. When federal and state jurisdiction exists in an issue, plaintiffs naturally select the court system perceived to be more sympathetic to their plight.
State and federal court systems share the same basic structure pictured in this diagram. Trial or district court is the level where the original case is heard. This is the type of court session commonly featured in television shows where emotional testimony and dramatic closing statements are made. Above this, the Court of Appeals represents the intermediate level. The purpose is to provide a tribunal between trial court and the highest court or court of last resort.
State and federal courts of appeal do not engage in factual inquiry, they determine questions of law. I am afraid that a TV show about appellate court would be dreadfully dull, as decisions are based on records from the trial-level hearings as well as briefs filed by both parties. After review, cases may be remanded or sent back to lower courts for further proceedings if written records provide insufficient fact. The state Supreme Court reviews appellate court decisions. The court's decisions may not be appealed to federal courts unless a federal issue is involved. The federal Supreme Court is the highest level court in the land. There is no appeal process. Rulings can only be overturned by a subsequent high court ruling or a constitutional amendment. Cases are heard by mean of a writ of certiorari. This is Latin meaning, the rule of 4. 4 of the 9 Supreme Court justices must agree that the case has merit before it is heard. Denial to hear the case leaves the lower court decision undisturbed. Please note, denials do not carry the force of a written opinion.
This map depicts all of the federal district court jurisdictions. Decisions in one district may influence other federal districts, but are not binding. When there are inconsistencies in the decisions among the 11 federal district courts, the U.S. Supreme Court will often step in to restore order with a decision. U.S. Supreme Court rulings impact all federal districts. All 11 districts must abide by them.
All roads eventually lead back to the U.S. Constitution and the Bill of Rights. This slide shows some of the common themes in school litigation and the amendments that apply. And finally, a note about court rulings. Courts pass rulings in the form of an opinion after reviewing a case. As discussed, this is referred to as case law. Depending on the court and jurisdiction, one or multiple judges will weigh in on a topic. These written opinions are not always easily understood at first glance, especially by educators. Our textbook contains many court opinions rendered in landmark educational cases. We will look at a process in this course called case briefing. It is a way to summarize lengthy court decisions into an easily read format.
Lastly, school districts all retain lawyers that provide legal advice. They are frequently called upon to provide professional legal opinions on questions of policy and practice. Mr. Law, I do believe it is time to conclude this episode, and direct our audience towards an activity.
Quite right, Miss Statute. In the dress policy activity, you will see an example of a school board policy that is actually beyond what is considered constitutional.
Finally. I have been waiting to hear this. It better be good.
Yes. I want to hear this too. I think our current dress code policy is way too lax. I do not like the t-shirts and rip pants those kids are wearing. They look like punks.
Oh dear. This could get interesting.